10 seconds, 5 seconds. Start. Learned senior counsel for the petitioner vehemently contends that there are in fact two tenancies in favor of the petitioner which commenced on different dates, and one eviction petition in respect of two tenancies is not maintainable. This objection by the petitioner was replied to by the respondent, stating that these tenancies stood consolidated with mutual consent. During these 7 years, there was not even a murmur of protest by the petitioner about one rent receipt being issued. The additional rent controller thus rightly concluded that the petitioner cannot now be permitted to rake up this stale issue. Learned senior counsel for the petitioner also raised the issue of the sale of a portion on the property of Shiv Kumar, which was for family necessity, and stated that instead of selling the property, the respondent ought to have borrowed from the market. This plea is stated only to be rejected. The petitioner cannot dictate to the respondent as to how the respondent has to solve his financial difficulties. The petitioner raised the issue of a larger accommodation available to the respondent, since it was stated that walls had been removed to make a large size room instead of a smaller room. In my considered view, this kind of plea only goes to show that the same is a frivolous attempt on the part of the petitioner to somehow deny the accommodation to the respondent landlord. In fact, the litmus test is whether there is in fact a bona fide requirement or not. The Supreme Court in Shiv Sarup Gupta versus Dr. Mahesh Chandra Gupta case held that while considering the issue of a bona fide requirement by the landlord, it cannot be expected that landlord must squeeze his requirement to protect the occupancy of the tenant. The requirement of the respondent cannot be said to be an exaggerated requirement. The available accommodation with the respondent is much less of only 3 rooms. In my considered view, there has to be at least a prima facie case on the basis of disclosure of facts for the tenant to be granted leave to defend. The additional rent controller has found no such case, and I see no reason to interfere with the said finding in the present revision petition. The scope of inquiry may be more than a revision petition under section 115 of the Code of Civil Procedure. However, this is to be seen as per the legal pleas as are available to a tenant. The summary procedure in section 25B of the said act cannot be defeated by merely making frivolous and vague allegations which can never be substantiated. It is the stage before trial, but there has to be some plausibility to the defense which could give rise to a conclusion that these are such facts as would require trial, and if proved during the course of trial would disentitle the landlord of an order of eviction. Applying the said parameters, the case of the petitioner cannot succeed. The petition is accordingly disposed of.